Thank you, Madam Chair, members of the committee. Thank you so much for allowing me to testify this afternoon in support of this important legislation that would create an extreme risk protection order in Rhode Island. My name is Ontel, and I'm a counsel with Everytown for gun safety. Everytown is the largest gun violence prevention organization in the country, representing 4.5 million supporters and more than 250,000 donors, including moms, mayors, survivors, and everyday Americans who are fighting for public safety measures that respect the Second Amendment and help save lives. The purpose of this legislation is to create a new type of civil restraining order so that when a person is in crisis and poses a danger to self or others with guns, law enforcement and family members are empowered to seek a court order temporarily blocking the person from having guns. When those who recognize red flags are empowered to act, they can prevent warning signs from turning into tragedy. We do know that in many cases, people who go on to commit violence display warning signs first. As the sponsor mentioned, a nationwide study of mass shootings from 2009 to 2016 revealed that almost half the time, the attacker exhibited dangerous warning signs before the incident. According to media reports, the mother of the 19-year-old who shot and killed 17 students and injured 15 others in Parkland, Florida, last month, contacted law enforcement multiple times about his behavior. Unfortunately, Florida does not have an extreme risk protection order law. I also want to highlight the impact that this policy can have on the problem of gun suicide. America is absolutely in the midst of a firearm suicide epidemic. Guns, as you just heard, guns are used in over half of suicide deaths, and access to a firearm triples the risk of death by suicide. But preventing a suicidal person's access to firearms can save his or her life. The estimate that you just heard about put the total at 72 lives saved by Connecticut's extreme risk protection order law. That's 72 lives, people's brothers, mothers, cousins, and their kids. This bill would create a process to empower Rhode Island families and law enforcement to temporarily block gun possession by people who pose a threat to themselves or others, while providing robust due process protections to people experiencing a crisis. The bills would create a new chapter within Title VIII. The chapter would establish and define red flag orders, how they can be sought, and by whom. The chapter would establish the factors that the courts must consider and specifically set out the standards of proof required for a court to issue an order. They will also set the duration of the orders and the processes for renewal and for termination. The bills will also establish the process by which guns are to be turned in when an order issues and how guns are returned when the order expires. As with all court orders that can impact individual liberties, the process created in these bills was designed to ensure both public safety and the due process rights of all parties involved. The bills establish clear and appropriately high standards for the showings that must be made before a court issues an extreme risk protection order. The bills make clear the factors that the court must consider and the burden that the petitioner must meet before an order can be issued. Petitions for these orders must be sworn under oath and must contain specific factual allegations in support of the claims that the respondent poses a significant danger to themselves or others. And there are safeguards in the bill to protect against abuse and to punish those who seek orders maliciously. Any petitioner, be it a family member or law enforcement officer who knowingly files a false petition or who files a petition with the intent to harass or to annoy someone else, is subject to criminal prosecution. The bill also ensures that all parties have an opportunity to be heard on the merits of a petition. Only in the most serious cases, where an emergency order is necessary to prevent imminent harm, can an order be issued before a full hearing. These emergency orders can only last up to 7 days, as you just heard, at which point a final hearing must be held. No final order can be issued before the respondent has an opportunity to be heard and to present evidence of why the order is not necessary. And the bill gives a person subject to an order an opportunity to petition the court to terminate it. I strongly urge you to pass this important legislation, and I would be happy to answer any questions.
Thank you. Any questions or comments for this witness? Thank you.
Madam Chair.
I'm sorry, Senator Raptakis.
You mentioned something about Florida did not pass earlier. You said something about the state of Florida because they did yesterday pass a whole package. I'm not sure if you looked at what was passed under mental health illness. There's a certain components, but you mentioned something earlier.
Yes, sir. Thank you. I mentioned that Florida does not have a law like this one that this bill would create in Rhode Island. It does not have an extreme risk protection order.
Well, have you seen what they passed as of yesterday? The state Senate in Florida passed a whole package that could be familiar to what we're having here today, the discussion on this bill.
I'm generally aware of that, yes.
Okay, thank you.